Tonight we have something really good, a hot topic in the news, but he's been charged with a crime. This is a show where I try to educate real stories. Welcome to Truth and Justice with Vivian King. I have another exciting show for you tonight. It's a little different, though, from my normal show. Tonight, we're going to discuss gender discrimination in the Houston Police Department. We have an officer, a former police officer, in the studio tonight who filed a gender discrimination charge against her sergeant in her department. And we're going to learn about the steps you go through in HPD to contest wrongful conduct of your superiors. Also, how the police can turn on you, one of their own, to try to file criminal charges against if they don't like you. That's another disturbing phenomenon with our police department. Once upon a time in my career, I was a hearing examiner for the city of Houston, and I would hear Houston police officer grievances and fire department grievances, and I always was troubled about the fact that a lot of minority officers were being complained about or against by their superiors, usually non-white, non-black superiors. And they would file charges on each other, and it just seemed to be very unfair. It bothered me. So when Officer Swilley told me her story, I thought it was interesting and that my viewers might be interested in it. So let's go straight to Officer Swilley's story. Thank you for agreeing to tell your story to my viewers.
And thank you for having me. The biggest problem that HPD have and officers are subjected to, once they report discriminatory practices of HPD, is the retaliation. I had 22 years on the force and didn't have any problems until I reported discrimination. In 2006, I was transferred from the Marshall Division to spearhead Chief Hurt's youth program, Kids at Hope. I complained that I wasn't getting any support from my supervisors for that project, and my supervisors, unbeknownst to me, opened a criminal investigation to see if I was embezzling money from the project, which I wasn't. When I was off from work, because they relieved me of duty without any type of complaint, on an AWOL charge. While I was off from work, they came in and confiscated all of my work documents, everything out of my cuticle, all of my personal items. They put them in a box, and like I said, unbeknownst to me, they opened a criminal investigation. I was only able to respond to the criminal investigation because I had so many job assignments at the time. I had a backup file at home, so I was able to answer all the questions. After the DA's office refused several times not to accept charges because there was, as they said, lack of evidence, the police department, internal affairs came back, well, my union, let me back up. My union representative told me that if I did not drop my pending EEOC complaint, they were going to terminate me. I stated that I hadn't done anything and I wasn't going to drop my complaint. Well, to make a long story short, I ended up going into a laudermill hearing. On a laudermill hearing is where they terminate you. I went to the laudermill hearing, and Chief Hurts, the first thing out of his mouth was that I have a charge where you were working an extra job on duty, which was not true. Then he tells me that he had two pending, he told me that he had two untruthfulness charges against me. I asked him who were the complainants, and could I see the complaint? And at that time, he told me to take it up with an arbitrator. At that time, I knew I was terminated, so I took the deal, knowing that I had not been untruthful, and I did it to save my job. Well, I found out later that the 2 charges of untruthfulness were actually felt to be not sustained 28 days before the actual laudermill hearing. So they actually suppressed evidence during the laudermill hearing just to get me, intimidate me into signing a waiver to drop the EEOC complaint.
So let's stop for a moment because you've given my viewers a lot of information. So I want to make sure that it's clear and that the viewers understand. And please, viewers, call in whenever you're ready at 713-807-1794. Okay, so first of all, I'm going to make sure I understand this. You were assigned to the Public Affairs Division of the Houston Police Department.
Yes.
You worked with a juvenile delinquent program called Kids at Hope.
Yes.
And that program had funding, and you had a lot of duties and assignments, but you had so many assignments that you actually needed some help and assistance. Is that correct?
I did, yes.
So you noticed that some of your male counterparts were getting the assistance in their public affairs programs, but you weren't getting the assistance that you needed with yours. Is that correct?
Yes.
So you just felt like something inside you said, this is just gender discrimination. Is that correct?
This is true. And I also was being told by one of the sergeants, and I don't want to name him at this time, that he felt too that I was being discriminated against because of my gender, and that I should go talk to Chief Hurt.
Did you go talk to Chief Hurt?
I did. I had an open door meeting with Chief Hurt because it was his initiative, and I didn't think that it was fair for me to have to go out in the community to solicit support for that project when my supervisors didn't want to do it. Actually, my supervisor told me that the project was creating too much work for them. So I didn't feel comfortable soliciting funds for the program when they didn't want to do it. So that was the topic of the conversation with Chief Hurt. And during the meeting, I told him that I felt that it was because I was a female. And like I said, shortly after that, my supervisors held a meeting, an unannounced meeting, and basically asked a lot of questions about my fundraising abilities. And that's how it escalated into a criminal investigation.
So what's interesting to me is that you're working in your public affairs division, you're working with a Chief Hurt initiative, Kids at Hope program. That program has to be funded somehow. And it seems like it would be some guidelines or procedures written internally, like every other HPD job. It wouldn't be something that you're having to create, not document, but you were documented because you were making monthly reports, isn't that correct?
Yes, I was doing my monthly reports every month. The problem was my supervisors, they didn't have a protocol, and I didn't find that out until I filed a civil case against them. And how I found that out, because once I filed a civil case against them, I requested the internal affairs files because I know I was innocent. But they told me that they couldn't locate the files. I sent a subpoena to Internal Affairs and was able to get a copy of those files. And in those files, not only did it vindicate me of all the charges, it also showed where the supervisors themselves did not have a protocol of even what to do with the money when it came in. So they just didn't do their job. And you're absolutely right. They should have had outline how the money was, what account it was supposed to go in. They didn't have any of that, and it stated that it was their fault for that in the internal affairs files.
All right, well, let's bring Ms. Victoria Plante into it. I might be saying your name wrong, so please introduce yourself to my viewers.
I am Victoria Plante-Northington. I am the founding attorney of the Plante Law Firm here in Houston in the Galleria area, and my primary area of practice is employment and labor law. And so I am very familiar with HPD practices and familiar with Ms. Swilley's story as well.
Do you have any comments about the procedure that she's described thus far?
Well, I would say that I think in retrospect, you can always say, oh, I should have done this. And as an attorney, I try to equip clients to be more proactive than reactive. And so in this situation, I think if Ms. Swilley had to do it over again, she would probably have it documented as it relates to her conversation with Chief Hurt at the time, when she alleged that she felt it was based on sexual discrimination, because oftentimes employers will deny that you even mentioned it, especially if it's a verbal or oral conversation. It always can be denied, and at the end of the day, it's your word against his word. And in practical sense, in civil lawsuits, your word against his word, the other side always wins because you bear the burden of proof. And so, as a practical matter, I would say that documentation is necessary. When you feel you have been discriminated, it's good to just put it in writing so there will be no misunderstandings.
So let me just interject here. So there are two things it appears that Officer Swilley could have done better in retrospect. We're not beating up on you, but just to kind of educate the public. And that would be to maybe tape record that conversation, because it's legal to tape record something as long as you're a part of that conversation. So you could have secretly tape recorded that conversation. And you could have then, if you didn't do that, or you could have, in addition to tape recording it, you could have sent a letter afterwards acknowledging that, you know, I enjoyed our conversation of today's date. We had this conversation. I thank you for allowing me to have the open door meeting today, Chief Hurt. Thank you for discussing this problem with me. Now that you're aware of the problem, what are you going to do about it? These are some of my thoughts. These are some of my requests and what I think you should do. Send a copy to him, and also you send a copy to your personnel file.
Exactly.
Now, I haven't had a job since 1989 in corporate America, but that's what I think I would do.
Yes. Exactly.
Well, and you know, and you have educated the public on that, but I did document I documented, and I gave him a letter in the meeting also.
Wow.
So a lot of this,
So
my
you
information.
gave him a meeting, but a letter, and you kept a copy of it.
I did.
But did you send it to your personnel file?
No,
Okay.
but because I kept a copy of that letter, it helped me.
Okay.
As I said, I did have a backup file of everything I did at home. And I'd like to also add that I was cleared of any wrongdoing. And as for the AWOL charge, you have to miss 3 consecutive days in order to be written up for AWOL for the city of Houston. And I had not missed not one day, let alone 3 consecutive days. The one day that I missed, it was an approved absent. I had called in. So they were untruthful when they said I was AWOL, because I did miss 3 consecutive days.
Wow, so this seems like you were treated very unfairly. So you had your open door meeting, you explained to the chief why you thought you were being discriminated against and the program you were working with, and then at that point you said you asked for a 48-hour notice.
Notice.
Okay, and explain to the viewers what that is.
A 48-hour notice is where they give you a notice, 48 hours, to meet with your attorney, which would have been my union attorney. Whenever,
So it's kind of in criminal law, the way you equated it in criminal law is like if the police officers are interrogating you and you say, wait, stop at this point, I'm not going to talk anymore without my attorney. So
same thing.
It's the same thing.
It's the exact same thing.
Except with HPD, an officer is not going to speak anymore until they get their union attorney.
Exactly. And usually when they call you in for these meetings, they already have the 48-hour notice prepared for you. In my case, they didn't, which was a violation of Local Government Code 143. They didn't have a right to. The first offense, when they said extra job, that was one thing. But when he was going, he couldn't be a party to that conversation when he's saying there's a criminal investigation or a complaint, and you're not giving me any type of, you're not giving me no information on it, other than you're asking me questions.
Right.
Without a 48-hour notice. So
after you requested the 48-hour notice, what happened?
After I requested the 48-hour notice, he immediately said the meeting was over, and that was on a Friday, and that Monday I didn't go back to work. I ended up getting, I was called at home, and they told me I was relieved of duty. Internal Affairs called me. And I asked the investigator why was I being relieved of duty, and he said he didn't know, but to turn in all my equipment. So the following day, I did just that. I turned in all my equipment, and I asked him, why am I being relieved of duty? And he said he did not know, and he too felt that he should have known something that day, but he didn't. But he said some type of misconduct.
Did he also tell you that there was a possibility that criminal charges were going to be filed against you and that he'd contacted the district attorney's office?
No, he did not. He told me he didn't know why I was being relieved of duty.
Okay.
So.
Okay, and then what happened after that?
I sit at home, and I was calling some of the officers that was still there at work and asking them, well, what are y'all hearing? Why am I being relieved of duty? And they said, well, Swilley, we're hearing you stole some money from Chief Hurt's youth program, and some of them were saying that they were told that I walked off the job. So I called Reverend Bill Lawson because I wanted to find out what's going on. And
now, why would you call Bill Lawson?
He's always been somebody that I truly have admired in the community, and I felt that he would do the right thing. You know, he would go and get it straight, get it taken care of.
Was he your minister?
No, he was not, no. And sure enough, he did go talk to Chief Hurt, and Chief Hurt told him that he was out of town and that he was told that I did, in fact, walk off the job, which was not true. So Reverend Lawson asked me to get my relief of duty letter to Chief Hurt because Chief Hurt was under the impression that I just walked off the job. And I did.
So who was lying to Hurt?
Evidently, it was people that was close around him. Chief Hurt did change the policy when he got back from out of town to where only the police chief could relieve a person from duty. So evidently, it was someone in his staff who was not being truthful to him. During a civil case, it was determined that Chief Hurt actually was untruthful to Reverend Bill Lawson because Chief Hurt said that he was told I walked off the job and he didn't know anything about that I had been relieved of duty, when in fact the records show that Chief Hurt was the one who relieved me of duty and he signed all the documents. So I guess maybe he was trying to cover for someone else. I don't know. I do know that the Internal Affairs vindicated me of the Internal Affairs documents, which they tried to hide, vindicates me of all the charges.
Okay. Is there anything that you want to interject at this time, Victoria?
Well, anytime you file a claim related to any protected activity, whether it's gender discrimination or race discrimination, religion discrimination, there's always the employer looking for a legitimate reason to terminate you. And so here they were trying to get legitimate reasons to terminate you because, of course, retaliation is not going to suffice under the law. So they have to have legitimate reasons, and usually it's building a file. It's starting with something as small as, oh, she's doing this, and writing her up on that, and then it progressively gets worse. And so my advice to anybody in the employment area that's filed a complaint is to protect themselves, and Vivian was very correct when she said you need to record the statement sometimes if it's legal to do so within your employer. Sometimes employers make it illegal for you to record, and I believe that's a general order now with HPD.
Really?
Is that
Yes.
There could be no recordings unless you tell the other individual you're recording, and of course that negates the whole intent of you recording.
You know what's interesting about that is that HPD has an internal policy of officers not being able to record other officers unless they give you notice, but yet officers will tape record defendants and citizens whenever they want, because there were a rash of cases a few years ago where officers would arrest 2 or 3 guys in a car, generally black guys in a car, and they would keep a little secret recording in the back seat, because when officers find one joint or one crack pipe and there's 4 or 5 people in a car, they don't really know who it is. Right. And so but in trial, they have to prove beyond a reasonable doubt that the crack pipe belongs to me, not you. And so there have been times when they've arrested everybody for the same joint or everybody for the same crack pipe. And so there came to be a time where they started recording people, secretly recording people. So we would have to, as defense lawyers, ask for a copy of that tape because it would be in the police report that the conversation was taped. And we would hear their conversation in the back, you know, and that's generally the type of evidence where people are saying, man, you know that's your dope, you better go on and tell the police that's your dope, that's not my dope.
Exactly.
A lot of times it would be helpful to the defense,
Yes,
actually,
yeah.
especially if your client is saying it wasn't his, because he would have that kind of conversation with his friend in the back seat. But there were other times where they would say things more incriminating.
Yeah.
So I haven't noticed them doing that lately, but there was a time for a few years they did that. And I find it interesting when I was a hearing examiner for the city of Houston how the police would have general orders for other police not to do things that they were doing to citizens.
Exactly.
For example, I remember when I first became a hearing examiner for the city of Houston, it was probably 1995 or 6. There had recently been a person shot in the back of the head. You know, it was that case where the guy was in the back seat, I think it was a Hispanic guy, and he jumped through his leg supposedly and took a gun that was left in the back seat of the patrol car and shot the police officer in the back of the head. So there was that situation, and then there were also situations where officers would arrest people just for anything, take them out of the car, take them down to the station and say they found a crack pipe in the back seat. But they would say they would check it was a procedure that they checked their cars, their shops before and after they transported somebody. Well, when I'm working as a hearing examiner, then I'm having officers getting in trouble for not checking the shop, and that's not the procedure. So at one point, but they would be blaming each other for things. Like I think there was a situation where a citizen turned in a gun that they found. They were just being transported for traffic tickets, warrants. But they found a gun. They weren't like a bad guy. They just found a gun. They said, you know, hey, cop, there's a gun back here. Well, when that cop turned it in, they did an internal affairs investigation because the cop said, look, I don't know where it came from. Maybe that guy in the back seat had it. Well, they had to interview everybody who had been transported in that shop for like a week because this car has been checked out to all these different people. So every officer, all these citizens had seen that gun, but nobody had said anything.
Too scared.
Too scared. And once the officer that finally admitted they saw it, they punished those officers. But the ones who said they didn't see it, they didn't punish. And I thought that was so unfair because there's a system where HPD punished the truthful officers.
That's right.
But they didn't punish the ones who lied. And they know that if their procedure was really to check the shop when they get it at the beginning of their shift and to check it at the end of their shift,
That is
then
policy.
every officer should have seen that gun.
That's right.
Of course.
And I was so angry that they had punished that person. Another thing I found out when I was a hearing examiner is that if an officer has an accident with somebody, they get in trouble because the city is not insured. You know, like we have car insurance, they're self-insured.
Oh,
So
okay.
they have to
So
pay for
they're
their own
sued
cars.
personally.
So every time a lot of times when officers have an accident with someone and they cause the accident, they'll blame the other person. They'll write them up or give them a ticket. And I used to wonder why that happened all the time. But when I was a hearing examiner, then I realized that if you as an officer, a street officer, patrol officer has an accident and you admit it's your fault, then you're going to be reprimanded for that because the city is self-insured. So they have to pay for it out of city funds. The city doesn't have insurance for their cars. So there's a lot of inconsistencies, you know, double whammies that I think are just not fair with the system. And I'm finding your situation to be a similar one.
Yeah. Well, I like to say I'm just happy that the prosecutors that Internal Affairs were calling to accept the charges. I'm glad they just didn't try to go along to get along because you're dealing with two law enforcement. And the prosecutors that they were calling, they were people who were fair and they wanted to do the right thing. Because other than that, I would have been indicted because there are police officers that serve on the grand jury and HPD was not going to be wrong. So I would have been indicted for nothing. We wouldn't have never been able to view the Internal Affairs files if not had been for a civil lawsuit that I filed. So I'm just grateful that those 2 or 3 prosecutors that they called trying to persuade them to take the charges, that they were good people. And they did the right thing.
And I'm glad to report that, too. Part of the reason why I like this story was because the prosecutors did deny charges. So that was the right thing to do in this situation because based on my talk with Officer Swilley, they didn't have, even though the internal affairs officers were trying to get charges filed, they didn't have proof that she'd embezzled any money. They had her bank account.
No complaint.
There was no complaint. They had her bank account. They looked through it. They had monthly reports that she was doing. There was a $25,000 grant, but they found out that that grant had never been officially funded. It was a technical grant that had never been funded into her account. So they didn't have any proof to substantiate it. But Officer Swilley's fear was that they could have just accepted charges first and investigated later.
Well, that's exactly what they did in Chief Bradford's case.
Right.
They accepted the charges while HPD came through the department trying to build a case on him.
Right.
So it was up to him to defend the charges. And that's why that case was dismissed, because I want to say maybe the second or third day, they came in with all this new evidence. And the judge asked them, where did you get all this new evidence at such a late stage in this case? And they said, we're not at liberty to say. And the judge said, case dismissed. And the case was dismissed for lack of evidence. But look at what Chief Bradford, he and his family, not to mention the finance that they had to spend for him to be cleared. But in my case, maybe the prosecutors learned from that case.
Right.
Let's not accept the charges until we see the actual evidence.
Well, they're different. I can tell you it's about 250 assistant DAs, and all of them are different. I think you just had some very fair-minded, mature, fair-minded prosecutors that, you know, use our city resources and county resources properly. Because without the evidence, they didn't accept charges. And like you said, in Chief Bradford's case, they accepted the charges, indicted him, made him pay for lawyers.
4 attorneys.
He had 4 attorneys, and lose his reputation in the community while he's on the news every night. So he, you know, they took the charges and he had to prove his innocence later. So he was guilty until proven innocent.
Yes.
So I am glad that the system worked properly for you.
Well, not only that, too, I know the prosecutors were really good people and they didn't accept it because there wasn't, it said lack of evidence, because I have the letter here, is that I had God on my side, you know, and everything just lined up for me. And as it went on, even though my termination letter states that they terminated me for untruthfulness, they still spread rumors throughout the community that I was terminated for embezzling money.
Wow.
So that destroyed my business, my nonprofit, and I ended up getting a dishonorable discharge where I can't get a job.
Wow.
You can forget getting I can forget getting a job in law enforcement. So it just turned out, either way it go, my career is damaged because of it.
Do you still have the TCLOS license?
I still have my TCLOS license because it's a license that I earned, and I do take my classes every year. That's mandated by the state of Texas, because just as I was able to get my internal affairs files, when there's a lot of officers who haven't been able to get their internal affairs files, I was blessed to get mine. I sent the subpoena to the wrong place. I didn't send it to the city attorney's office. So I ended up getting my internal affairs files. So the evidence is there, and I'm just hoping that one day I can be vindicated and be able to use my license. You know, after they told me that they couldn't locate the files, and then I get the files, they requested a protective order on me. I've actually been under a protective order for 3 years where I couldn't discuss this case at all. None of the attorneys that I had could discuss this case at all. So just like now, I waited it out till the 3 years were up, and I'm letting people know what happened to me. I will be vindicated, and I will be able to lose my law enforcement license again.
So Victoria, let's have some comments from you as an employment lawyer. Do you want to comment about what she's saying, or maybe what some of the procedures are?
Well, it just speaks volumes to a person who fights for justice. And sometimes when you fight for justice, At the end of the day, you may be without a job, as Officer Swilley is, and it is something that deters a lot of people who know they have been wronged from filing any kind of complaints. I'm dealing with several cases where individuals who have been discriminated against personally, or they know someone who works with them who has been discriminated against, and they won't vouch for that person because they're scared they're going to lose their job. And so people like Officer Swilley, they're unique, they're different. They're our new civil rights movement, really, in essence, is what it is. We have no Rosa Parks anymore, we have no Martin Luther King. So we have the individual who stands up in the workplace and says, this is unlawful and I will do something about it. Unfortunately, sometimes on the other end of that is they lose their job. But they lose their job, but they gain so much personally, but also a lot for the people who may be still at the employer.
Yes.
What do you think
Things
that
change.
they've gained? Like the people who did retaliated against Officer Swilley, what do you think, what changes do you think were made?
Well, she mentioned one in that they didn't accept the charges. Yeah. Perhaps they learned from the Chief Bradford situation, don't do that. That's just, you know, eating up money. Taxpayers won't like that. And they learn how to cover it up more. And so they implement new policies. I think when another officer that I know that worked for HPD recorded a conversation, subsequently they enacted this general order that stated you cannot record. So it's different things they do. There are different things they implement to try to keep you from reporting it or keep you from proving it. And so, but getting back to Officer Swilley, she has sacrificed so much, and others will benefit because they will be very mindful of her case next time. And they will say, oh, we better not do that because we had to spend all of this money on this lawsuit. We had to use this amount of manpower. This is not beneficial. And, you know, some people just have morals and they say it was wrong and we shouldn't do it. But some people you have to legislate it. You know, you can't change the hearts of people. You can litigate it, but you can't change the hearts of people. If they're going to discriminate and retaliate, that's what they're going to do because it's in their hearts to do it. But when you hit them financially, it makes them think. And so that's what employment discrimination is about. That's what the civil rights movement was about. That's what the sit-ins and the boycotts was about, you know, making sure they feel it where it hurts in order to change.
Well, one of the things I found interesting in learning about the City of Houston police officer cases is this laudermill hearing, because you don't see that in the private sector. So it's my understanding, by doing a little research about the laudermill hearing, the termination hearing, that's a 1985 Supreme Court case, U.S. Supreme Court case, that talks about government employees having a property right to their job, where if you work for Exxon or Shell or J.P. Morgan Chase, like I did, that's a private company and you don't have a right to your job. You work as an at-will employee, so that means your employer can basically fire you at will. But apparently with government jobs, you have a property right to your job, so you have, so the due process clause comes in, that you have a right to have notice, a hearing, and an opportunity to at least state your case. So can you more fully explain what a laudermill hearing is?
Yes, a laudermill hearing is sort of your last effort to go in before the chief and explain what happened. And
now, do you go into those hearings, or do
I
they
have.
use union lawyers?
I have gone into those hearings with an HPD officer, one HPD officer. I've gone into a meeting with Chief Hurt. Okay. And at that time, you make your case for your client. You bring out the weaknesses in their case, and, you know, always bring it from the perspective, if this goes all the way to trial, what are we going to be dealing with? And do we want that? Can we resolve it now here? And more likely than not, they are stuck. they're not going to be moved. Let's do it. Do what you need to do, but we're going to do what we need to do. So the laudermill hearings really are not true hearings. No. They're really not true hearings. They're facades, but they have to show that they're giving you due process because, I mean, you can identify with that.
But in the due process in the criminal world, you actually get something. Here, it seems like it's just make-believe. I mean, do you think people are ever convinced in these laudermill hearings to persuade the employer? Is it persuaded to allow the employee to keep their job, or is it just a done deal?
Most of the time, it's a done deal.
Okay, I can't speak to the all of the hearings or even most of them. The one that I went to, I could say it was a done deal. The document was already written, the notice of removal, everything was done. Other than we need to give you this hearing just because the rules say we have to give you this hearing.
Exactly.
Well, you know, so many things that started in the 70s and 80s that made sense that were based on fairness seem to be gone now in this new millennium. So now it's like the Miranda rules. You have the right to remain silent. Anything you say can and will be used against you. But now officers trick you into saying things. There are 1,000 other excuses for to go.
The Supreme Court says it's okay for them to lie.
Yeah, the Supreme Court says it's okay for the police officers to lie to you. I mean, so everything has been watered down, even though we still have this pretense of fairness. And that's one of the things that bothers me. I don't know, it's because of my Libra personality or, you know, my balancing act.
You're a Libra too.
I am a Libra.
I'm a Libra too.
Yeah, my birthday's coming up in a few weeks. But so I wonder, that bothers me that everything is watered down. So we have this U.S. Supreme Court telling us that we have to give government employees this hearing, but yet the hearing serves no purpose at all.
Exactly. It really doesn't. You can gather evidence there. I mean, mostly attorneys go there as a fact-finding mission and try to get as much information. You try to persuade, you try to get them to see that this is the person's livelihood. I usually do the legal aspects of it, and the employee usually speaks from his heart, how this is going to affect his family, how he's given so much to this this department for so many years, and how this is going to mar him for life. So he adds more personal, and I add more of a legal aspect to the hearing. But ultimately, it results in an arbitration, which is a whole nother issue that is pretty much a kangaroo court, for lack of a better term. Just there, and I always say there's a conflict of interest with arbitrators because they're being paid by HPD.
Hold on, let's talk about that in just a moment. We have a call. Caller, thank you for calling Truth and Justice with Vivian King. You're on.
Oh, how you doing today?
Hey, how are you?
Okay, it's my second time calling. I called you about a couple of weeks ago. Look, my understanding is that an employer cannot fire you like if you've been on a job 6 months, you have so many doctor's appointments. And I'm wondering, prior to that, what coverage do an employer have where the employer won't terminate you because you have so many doctor's appointments?
Okay, Victoria, can you speak to that?
Yes, you're addressing the Family and Medical Leave Act, which is a federal act that protects employees who work 1,250 hours the preceding year before they request leave. If you work 1,250 hours before you request leave, then you could get up to 12 weeks of leave, and your job would be protected.
What I'm wondering is, if you have so many doctor's appointments, not leave, you know, my understanding was after 6 months, you wouldn't have a problem that some kind of law or something where the employer can't fire you. But I'm wondering, prior to that, what coverage do you have if you have so many doctor's appointments and they say, hey, man, you got too many doctor's appointments, you got to go?
Well, as Vivian said, it's an employment at will state, and so if there are doctor's appointments, it just depends on the individual employer's policy. You would need to look at your handbook. Some employers give more than federal law requires, and then some give only what the federal law requires. And I'm giving you information just based on what the federal law requires. And if you're talking about doctor's appointments, you are really...
Like in my case, I have allergy appointments every Monday. So that's either I got to go to get allergy shots 4 or 5 times a month. And then I have my regular doctor's appointment, which is every 6 weeks with general medicine. I'm just wondering, you know.
Well, the problem is if you haven't worked there for 12, basically 31 and a half weeks, 32 weeks prior to that, it appears that based on what Victoria is saying with the Family and Medical Leave Act, you don't have a right to do that, but it looks like you probably need to try to find a Saturday doctor that you can get those allergy appointments or an off day, don't you think, Victoria?
Well, if you can work around it until you build up the 1,250 hours, and then you can take intermittent leave, which means you take it.
I go to Ben Charles, so you know how that.
Oh well, I do. Yeah, I have a client that actually has gone to Ben Taub, and that was an issue with her, and she was written up. And they were requesting, she was FMLA qualifying, but she had to bring in documentation. And she was saying, well, it's taking me all day. It takes a full day to get you the documentation you need. And then when you bring it, it's not sufficient for them. Employers don't typically like individuals taking FMLA leave because they have to keep the job open. They cannot fill your job while you're protected under FMLA. You possibly could have an Americans with Disabilities Act. I don't know what type of health condition you have, but it would be advisable for you to get some type of diagnosis to see if that's something that could possibly qualify under the ADA, and perhaps a reasonable accommodation could be offered. I know under the ADA, your employer has to offer a reasonable accommodation.
And that's the American with Disabilities Act. But do keep in mind, the lesson here, though, is if you work in the private sector, you can be fired. Without...
I voted early. I voted for you.
No, you haven't, because it doesn't start till October 22nd. But don't forget.
I mailed my absentee ballot yesterday.
All right. Well, then, yes, you're right then. You sounded too young. You know, usually the people that absentee ballot are older people that can't get out. But I'm excited about that. Thank you so much. Please spread the word. And thank you for calling in. Good luck with those allergies. They're killing me right now, too. I'm picking up a prescription when I leave here tonight.
Well, that's just one of my conditions. I got chronic neuropathy in my foot, and it hurts 24 hours a day. The pain never stops. Oh.
God bless you. I'm so sorry. Keep watching and keep tuning in, and hopefully you're enjoying the conversation tonight. Okay.
Take care.
Thank you. So we were talking about arbitration right before you left. So after after she gets the, what was the last step?
Laudermill. She gets
after the
arbitration.
Laudermill, then if she doesn't like that, she goes to arbitration. And with HPD, the arbitrators are appointed by the City of Houston City Council. Isn't that correct?
No, you can select, you can speak more on that.
Yeah, you can pick it along with your union attorney. But like she said before, there's a conflict of interest there. A lot of the hearing examiners have been they work for the city. They get paid by the union. So basically, there is a conflict of interest.
Now,
some have been there 20-some years.
If people came to me, if I was at next step, because I think when I did it, I was the 4th step, where people appeal their decision. So it probably was after the laudermill. I don't know. For me, it would be more reprimands I was looking at, I think. But when they appealed it to me, I had a real independent thought process. It was not what they would want me to do. I did it based on what I thought was fair. But generally, it would be some type of compromise. Like if they wrote somebody up and I thought it was racist or unfair or officers picking on other officers, I would say let the reprimand or the punishment stay in their personnel file for 1 year, and if there's no other misconduct, take it out. And so, because I would always get the sense that they were trying to build a nasty file on someone so they couldn't get promoted in the future to some of the good jobs. So I felt like, since the grievance was probably small, as long as they took it out in about a year, and the person hadn't no new infraction.
Well, that's fair.
Let it go. And that's the kind of, I did that almost all the time. And so when they would appeal that to the arbitrators, for me, they would go to the arbitrators. They would almost always go along with what I said, because I kind of just had a compromise.
Right. Well, even in my case, with the arbitrator, there was a conflict of interest, because even when there was an ex parte violation committed, where the city attorneys were talking to the hearing examiner, the hearing examiner did dismiss the appeal because that was a state violation. but they didn't uphold my position as a police officer to come back to work. So either way it goes, it was stacked against me because of the retaliation. It was like, okay, you broke the code of silence to go against the police department, and now you got to pay the price.
Excuse me, I have another call. Caller, thank you for calling Truth and Justice with Vivian King. What's your question or comment?
Hi. I wanted to know, is there a statute of limitations where you can file a maybe lawsuit against a former employer if you're no longer there anymore, if you feel like you have been discriminated against?
Turn your TV down. It's echoing in the back, but Victoria's going to answer that question.
Okay.
There is a statute of limitations depending on what you're saying. Discrimination on the basis of what?
Oops.
We lost it.
I'm sorry, caller. I didn't mean for you to hang up. I just wanted you to turn your TV down and talk inside the telephone. So if you want to call right back, you can. All right.
Okay. But you were talking about arbitration.
Well, the good part, one thing that did come out in my case was I met Ms. Plant, and like you say, there's a layer of where people think is fairness. Well, the union attorneys are not always, there seems to be a conflict there also because they are part of management. And the majority of people that I know that was terminated after they reported discrimination, the union attorneys did not properly assist them, represent them. So Ms. Plant had what they call a alternative to unions, and I wish I had known about her first, where she basically educates you on what your rights are, because there's a lot of things that my union attorneys didn't tell me, and maybe she can elaborate on her.
Well, I believe that unions are, I don't want to say anything.
Let's see if this is our caller.
Okay.
Hold that thought, please.
Sneeze.
Okay, ma'am. Hopefully that's you calling back.
It's me.
Okay, sorry. So is your employer, your former employer, were they a private company or a government company?
Private.
Private, okay. So what's the general, did you file an EEOC complaint?
I did file a complaint.
Did you get a right to sue letter?
On the basis of I was going to, from my understanding or from what I got from it, I felt like it was racist. But when I went to EEOC and had my case, told them what, everything that happened, they told me that once they did their little investigation or whatever, I don't even know if they really did an investigation, because she pretty much told me, the representative from EEOC pretty much said that, well, this really doesn't sound like it's racist, because it was just so subtle. But I filed a complaint. First of all, I was there for 9 years. Nothing was in my record. And I was clean. When I went to my Human Resources Department, that's the very first thing they asked me was, am I on the write-up? No. And went through that whole process. And I ended up resigning anyway. I just resigned early. And after I thought about it, I said, maybe I should have fought a little harder. But I really do think I kind of, shook some things up, because after I left, I heard that things, changed some. So I just wanted to know, I turned on, I was flipping to the TV, and I saw you guys, and I wanted to know, maybe I can go back and do something, because I was going through some papers, and I still had all of my evidence. And I said, maybe I need to hold on to this a little while longer. And this was like in 2009. So since then, I'm working somewhere else, but I just wanted to know, is there a statute of limitations?
There is a statute of limitations. There are several statutes of limitations, but if you've gone to the EEOC and they've given you your right to sue, you have 90 days from the date that you receive it to file a lawsuit in state or federal court. If you do not, you waive your right to sue.
Okay.
So there's really nothing. There is a 1981 action that could be brought within the 2-year, within Texas. It's a 2-year statute of limitations. So that's only related to race discrimination. 1981 is only for race discrimination. So if it were gender or any other protected activity that is not race, then you would not have any other recourse. But it appears to me, if it's 2009, your time would have expired.
Oh, okay.
And let me tell you, young lady, why it's important that you vote, because I'm older than you. I'm in my 50s. You could sue people in the 70s and early 80s just about for anything, your employer. There were a lot of suits that were won. But when President Reagan became our president, he started putting all these restrictions on EEOC. The restrictions that Victoria is talking about, it became that you couldn't just directly sue your employer anymore. He changed the law to where you had to go to the EEOC first. And as you know, that's just another layer of bureaucracy where they're not going to do anything about it. But before, you could just directly sue your employer, get into court, and let a jury decide. But now you have to go through EEOC, and they have to give you a right to sue letter with this short statute of limitations to try to find a lawyer that'll take your case. And basically, it just shut down the EEOC claims. And President Reagan did that. So let me give you that history lesson. And that's why young people need to vote, because it is very important who our Supreme Court justices are. And remember that the next president will probably put 2 people on the Supreme Court, and we don't want those kind of courts that limit people's rights to sue their employers or anything that's fair or unfair. Do you follow what I'm saying?
I do. And like I said, I wanted to know that because I never know when I may be put in a situation again like that.
Well, document. That's the only thing I can tell you.
I had a whole volume of stuff, and that's why I couldn't believe that, EEOC.
Just make sure that you're documenting it the right way. After talking to employers, you're putting documentation about that conversation in your personnel file. You're tape recording conversations and keeping them.
Okay.
Because just writing it down yourself is still just like your memory. They're not going to believe it. But if something happens, document a conversation and make sure you send it to your employer and to your personnel file. And I think Victoria wants to say something.
Yes, I'd just like to add that next time, if you're in an unfortunate situation where you have to go to the EEOC or you think something is wrong, at the moment that you think something is wrong, it's best to start documenting, start recording, start doing whatever you can to protect the evidence. And talk to an attorney prior to going to the EEOC. I know so many individuals who have come to me after the fact, after the deadline has expired to file with the EEOC, and they said, oh, the intake officer told me I didn't have a case. Well, there's nothing we can do in law to remedy that situation. And so it's best that you be educated and informed, and the best way to do that is not to go to a governmental entity that is backlogged. The EEOC is still working on cases that I have pending there for now 2, almost going on 3 years. And so they're extremely backlogged. They really don't want cases they perceive aren't good cases, but an employment law attorney will be able to assess your case in and out, and just understand that most of those intake officers at the EEOC are not attorneys, and so they don't know the new areas of law and the different aspects of law.
Okay.
Okay?
Okay, well, thank you very much for the information.
Thank you for calling in, and God bless you. Okay.
All right.
Well, we're getting a notice from our director that we have 5 minutes, so I don't know. I will let you go first to start saying your closing comments of what you learned and what you'd like citizens in Houston to know about your story, and then I'll end with Victoria.
Well, like I said, I was able to get the internal affairs filed, and I'm going to go in front of City Council on Tuesday, October 16th at 1:30, and ask the mayor to open my case because I'm innocent and the evidence proves it.
Okay. I appreciate and admire your spunk and your dedication, because a lot of times when people go through something this emotionally charged, because police officers really expect to work until they get ready to stop working. And when police officers turn on each other, it's a sad day, especially about something small like this. I could see it if it was a shooting or something that's really morally, you're grappling with morally. But this is something that's just evil.
Well, and not only that, too, anytime a police officer is afraid to come forward to report any kind of misconduct, I don't think they should be retaliated against.
And there should be laws about that. That's one of the things where we keep talking about we want a civilian review board. We also need laws passed and general orders passed that if you report misconduct of another officer, that you are actually protected and not retaliated against, that you cannot lose your job. I mean, well, and unfortunately, we've talked about that before, exactly. I think at those town hall meetings. And that's why so many officers don't report what other officers do to abuse people, citizens in the street,
Exactly.
because they know that they're going to be retaliated against for being the Good Samaritan.
Exactly. Well, I'm hoping that's what come out of my case, is that my case will be a poster child to initiate and create citizen review boards with a committee that would have reviewed my case, because it didn't have anything to do with police brutality.
Right.
And also to try to get policies or laws put in place to protect police officers who report misconduct of other police officers.
I agree. Okay, well, we have 3 minutes, and I'd like for you to use that time and wrap it up and say whatever you want to say.
Well, first of all, I'd like to thank you for extending the invitation to me, and thank you for opening up this area. I know this exceeds the scope of what you normally do, and so this is a new area for you and your viewers, but it's a very, very important area because we spend more of our time working than we do sometimes other things. So it's very important that we know our rights, and education is power in essence, and if you don't know, then you're probably going to be taken advantage of. So it's just best to know and have it in your back pocket in case you need it. What I've seen in my 15 years of practice in employment and labor law is employees come in and they're not equipped. And so what I try to do as a law firm is to teach and to, of course, encourage and to advocate on their behalf. Sometimes it works out, sometimes it doesn't. I'm a believer in the Lord, so I truly believe that in the end, the person who does wrong gets what they deserve, even if the court system doesn't do it. But I would encourage your viewers to get more involved in knowing what your rights are. You can Google a lot of these things. Title VII, Americans with Disabilities Act, they call it ADA, FMLA. Google these things so you'll have general information and be equipped to deal with the situations that may arise at your job. Also, I will be having a seminar on October 20th at my office. The address is 5177 Richmond, Suite 1275. It's in Houston. The zip code is 77056, and the telephone number is 713-526-2615. It'll be next Saturday. I have 2 sessions, 11 a.m. and a 1 p.m. You will need to RSVP to that number, 713-526-2615. And in this seminar, I will be talking a lot about what we were talking about tonight, but more or less getting into the practical aspects of what you need to do at your job, taking questions and answers.
Well, we're going to have to wrap this
Okay.
up now, Victoria. Thank you so much for giving us your time tonight. Please Google Victoria if you need to know anything about employment law and your employment rights. Again, her name is Victoria Plante-Northington. And also, let's be in prayer for Officer Swilley and her crusade to try to help HPD create policies that allow officers to report misconduct of other officers and be protected and not be retaliated against and fired. Thank you for watching Truth and Justice with Vivian King. I want to tell another great story. Hopefully next week we'll have Sylvester Turner on, and we'll talk about your driver's license and some of the laws having to do with the exorbitant fees that are assessed when you have DWIs and different surcharges on your driver's license. So make sure to call me at 713-222-2019 if you want to tell your story. And remember, I want to tell your story. Thank you for watching. Thank you for tuning in again. Tonight we have something really good, hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real